Mr. Chairman, members of the committee, good to see everyone. My name is Jim Perdue, Jr. I'm president of the Texas Trial Lawyers Association. I'm here against the bill. You have a bill in front of you for which there's nobody testifying for. I appreciate the opportunity to come here and testify against. If I walk through this bill, I can walk through it backwards, beginning on page 4, line 4. This bill creates a limitation of liability unprecedented in Texas law. Nowhere else would you move the concept of liability for vicarious liability, and what you have in these cases is the right to control or an interruption of safe conduct by the driver, or worse, the employment of a sex offender, and the multiple media reports we have heard about rapes by these drivers or by horrific wrecks causing injury to passengers. And in this bill, rather than the scheme that we have now where a plaintiff must navigate the law of vicarious liability and navigate the rules, this bill sets a limitation of liability on those companies unless the company, not the driver, the company committed a crime. Not a gross negligence standard, not a heightened standard, rather a criminal penal code, which is undefined standard for a move to complete and total immunity for, as I understand it, the lifts of the world. Going backwards in the bill, then you have a legal impossibility that is built into this statute on page 2, line 5. For filing a case, there is a notice standard, and obviously we have Rule 13 where a lawyer must, when signing it, is an officer of the court and representing that the allegations are true. This bill does two things which are legally impossible to achieve as a predicate for any lawsuit against a ride-sharing service. In the bill, there is an affidavit of the claimant's counsel required, starting on page 11, line 2, that requires the lawyer to set out the factual basis for each claim and the negligence, if any, of the errors or omission of the company, thus requiring the lawyer to testify under oath about the liability facts related to the ride-sharing service, of which are unknown at the time of filing the lawsuit. The vicarious relationship is understood, but the details of what the company did, it requires discovery. So you have an impossibility. And second, even more insidious, there requires something that is nowhere else anywhere in the law, an affidavit from an expert to say that the damages in the case exceed the insurance, which may or may not be known because there's two levels of insurance in these types. So number one, you don't know the policy, which is required by this affidavit. And two, you have an expert of some unknown who can say the damages. And it just says damages if you look at line 17. Well, damages in a claim like this include pain and suffering, mental anguish, non-measurable damages that are left to the discretion of our juries. They are not the area of expert testimony. So you have a legal impossibility as a predicate to even bring a claim. That's why we're against the bill, and I appreciate, Mr. Chairman, the opportunity to testify.
Members, any questions? All right. This is the first time hearing this. So I look forward to talking to you about it.
I appreciate the opportunity, Mr.
Thank you, members. All right. Does anyone else wish to testify on, for, or against House Bill 2788?